Science can do amazing things, including the analysis of evidence. It can be good or fast, but it's hard to be both. We'll talk about forensic science right now on the LawWorks.
From West Virginia Public Broadcasting.
Closed captioning for the LawWorks is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The LawWorks is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
Do you watch CSI or Bones? Hard to believe how all that stuff works, isn't it? Yes, it is hard to believe. My guests are the Honorable Russell Clodges, Judge of the Circuit Court of Monongalia County, West Virginia, and Dr. Keith Morris, Director of the West Virginia University Forensic and Investigative Sciences Program. Keith, Judge, thank you for joining us.
Welcome to you.
Forensic Sciences, Keith, you're deep into that. What do you do?
I'm the Director of the Forensic Science Program at WVU. Before I moved to Morgantown, I was the Director of the Forensic Science Laboratory in South Africa for 6 years, and we were pretty busy there, to about 200,000 cases a year, and experienced a lot of things that forensic labs experience here in the U.S.
So you really did this stuff we see on TV?
Yeah, I actually did it.
So do you watch these TV programs about that?
Yeah, I've watched some of them. And
what do you think?
Well, some of it's interesting, some of it might have a smidgen of truth, and some of it is just pure entertainment.
So it's not scientifically accurate necessarily?
No, not necessarily scientifically accurate. It's sometimes very, I've seen them do a DNA analysis out of a printer, which is quite interesting. And if we could get them done in the time spans that they show, that would be wonderful. I think the courts would be very happy.
I saw an episode of Law and Order Special Victims Unit just recently, and one of the things they did in the space of a morning was they found sand on the victim's body. It was a murder case. They found sand on the victim's body, and within the space of about 2 hours they had identified the beach that it had come from along the New York coast. And I can only fantasize about the work it would take to analyze a sand sample to be able to say where it came from.
Yeah, that would be an incredible amount of work. I would just imagine if one had to go to a geological survey and find out the information on sand compositions on beaches, I don't think their database would be large enough to make that kind of inference.
Well, yeah. Science can do wonderful things, but a number of years ago I was involved in a criminal case. It was a wrongful death case, presumably. I was a prosecutor, and the mechanism of death was that the victim had ingested chemically pure cyanide. And the operative term was chemically pure. There were no traces of anything else in it. We could not identify where it came from. We could identify places that had chemically pure cyanide, and within the area there were 3 or 4, but we couldn't say it came from this bottle on that shelf in this lab. And so I asked the forensic scientists, what would it take to be able to do this? And truly the answer I got back was, turn 2 or 3 chemistry graduate students loose on it as a PhD dissertation, and maybe after a couple of years you would have some idea as to where it came from. But it would require spectral analysis to perhaps a higher level than the technology existed for at the time. Judge, you try cases where this evidence comes in front of you. How do you know what's good science and maybe not so good?
Well, certainly from a judge's standpoint, we look at what the law requires, which is interesting because what the law requires is not always what science requires or the scientists require. But our Supreme Court has made it pretty clear what type of scientific evidence comes in. They've indicated through case law that some of the more established forensic sciences, and examples being fingerprint and evidence like that, comes in without too much question. And then the other kinds of science, if it's more, I shouldn't say unique, but newer, then you have to apply the standards set up by the United States Supreme Court in Daubert and the cases that follow that.
Daubert was a case that was in front of the United States Supreme Court in 1993, or they decided it in 1993, and they laid out the tests, the test that you apply to scientific evidence. Scientific evidence is basically generated by tests, and then whether the court lets it in is subject to another test, and that's the test that was in that case. They said you have to know whether the theory or technique could be or has been tested, challenged. It's, right. In science we talk about repeatability. You have to make sure that the test measures what it's supposed to measure. The second standard is it has to be peer-reviewed and disseminated or published. Other scientists have to look at it and agree that it works. Third, you have to recognize where the potential is for error in it. You have to know where the mistakes are. And fourth, you have to have standards that control how you do the test. And you look at that pretty closely, especially that fourth test, whether the standards were applied in performing the analysis or the test that comes into your courtroom.
Oh, certainly. I mean, and that's kind of, even with the accepted sciences, you need to look and make sure that the science has been applied properly to the case at hand. So not only does the science have to be reliable, it has to be relevant. It has to be applicable to the issues that you're deciding, and the principles or the procedures, the protocols that are established in the sciences have to be followed. It's like anything else. You know, things can be done right, things can be done wrong, so you have to ensure that whatever's being presented has been done properly. And
all that has to be documented. Now, if you ever took a science class when you were in college, you probably had to write a lab report. And what's the first section of that lab report? Methodology. And the reason for that is to demonstrate to the person who's reviewing it, whether it's your teacher or a judge or a laboratory supervisor, that you did the thing right. Because there's lots of ways to screw up a laboratory test.
Absolutely. And I think what, in terms of standards, there's multiple standards that one can look at. The standard for the analytical methodology. Am I applying the method in the correct manner? Am I following it in the correct sequence? You want to make sure that if I need to add a certain reagent before I do something, that you actually do it in that fashion.
A reagent is a chemical.
And then when we get to testing, does our method actually give us the result that we desire? Say, for example, if I was doing a drug analysis and I'd received a white powder and I was using a technique and I get a result and it says to me that this is cocaine, well, I want to make sure that if I apply this technique on something which is cocaine and I know it to be cocaine, that it gives me the same result. So that is a cocaine standard. Or if I'm measuring something, let's say, for instance, if I'm weighing out a certain substance, and drugs is one that comes to mind, depending on the amount that was seized during that case, there might be a different sentence on that individual. And so if I weigh it and it says it's 100 grams, it is in fact 100 grams. So if you had to go to the gas station with the prices that gas are today, if you're putting in 40 gallons or 20 gallons or what are you putting in, are you in fact getting 20 gallons? And there'll be a little sticker on the gas pump which says this was tested by the Standards Bureau. And the same thing for us, but on a very different scale, both mass and length, but also on chemicals, that this is in fact the chemical that's...
Well, and to go back to your first example, where you want to make sure that if you're testing for cocaine, when you have cocaine, it tests positive for cocaine. But you also want to make sure that if you test something that's not cocaine, It shows it's not cocaine, too.
And those are two things, and it comes back to Dorbit as well. They talk about error rates. We've got two main kinds of errors. You get a false positive rate and you get a false negative rate. Right, yeah. And those in a method tell us how good this method is, or its discriminating ability. So, for instance, if I get evidence into my lab and I analyze it and I get a result and I say this comes from person X, but it doesn't, well, then we could have an individual in court who isn't the perpetrator of the crime. And that's a problem, especially for the courts. But for the other scenario, if I get it and it is from this person, and I say it's not that individual, and we let them go, they might commit another crime. And so it's a very delicate balance that one has to follow, because unfortunately, they're not exclusive things. You don't have a perfect test. There is always a rate of error one way or the other with every test.
We probably ought to mention that your program is the Forensic and Investigative Sciences program at WVU. Judge Claudius, you teach in that program.
I do.
What do you teach?
I teach a class called Court Testimony, and basically the design or intention of the class is to prepare the students, or at least to begin to prepare the students to communicate the information that they arrive at or reach in the laboratory in court.
We're talking about forensic sciences. My guests are the Honorable Russell Claudius, Judge of the Circuit Court of Monongalia County, and Dr. Keith Morris, Director of the West Virginia University Forensic and Investigative Sciences Program. I'm Dan Ringer, and this is The Law Works. And one of the great bits of fun that I get to have each year is Judge Claudius will ask me to come in and cross-examine some of his students, and we try to teach them where their assumptions are leading them, to show them that you can't just believe what you're told. You have to understand it yourself. And one of the questions I always ask is, do you know what you know? And the students will always agree, yes. How much is 2 + 2? It's 4. So, well, do you know what you don't know? And usually, if they have not considered that question before, they'll stare at you blankly, or they'll expostulate something like, that's impossible, you can't know what you don't know. But you do. If I ask you how far is it from the Earth to Jupiter, chances are you don't know that. So don't guess. Normally you just say, I don't know. And that's good, because you know what you don't know. You know that you don't know how far it is to Jupiter. So with tests, the forensic examinations, it tells you certain things, or it lets you lead you to certain things, but you have to understand where it doesn't take you.
Yes.
Also,
every methodology has a limitation. Give a practical example. If I do a fingerprint comparison, I might have a latent print which was lifted from a crime scene, and that fingerprint examiner is going to look at that latent, and there might be some information in it, but there isn't enough information in order to come to a conclusion which will give you that reliable result every time. And so knowing what that limitation is will then give you a result where you get an inconclusive for that analysis. And the same is true on a small sample. You are able to analyze very small samples, but there is a limit to which your test will tell you whether something is present. So if I think of an example, if I'm testing for a poison, then my method will tell me what my limit of detection of that poison is. If I analyze it and I get a result which is below that limit, I can't say that it isn't there, I just cannot say that it is there. And it could also not be there, but I don't know that. So that describes what the limitation is of your evidence and how far you could take that evidence in your presentation in court. So knowing your limitation of method and your knowledge of the environment in which we live is fundamental to interpreting that evidence.
Well, the people that are in your program, I say, for example, I apply to WVU and somehow get accepted, and I say, I want to be a forensic scientist. So I come see you and say, let me in your forensic science program. Is that how it works?
Well, there's some prerequisites that you need to fulfill, and the first thing is it's a science program. So you have to go and do all of the basic sciences, your biology, chemistry, calculus, physics. You've got to have an understanding of science in order to apply scientific principles to the analysis of evidence in order to interpret it.
So you have to be a scientist to become a forensic scientist?
You have to be a scientist to become a forensic scientist. You can't just, it's not a case of just running in, I can do things, I can fix a car, but that doesn't make me a mechanic, because I can change the oil, but I don't know what's going on in that vehicle. To be a scientist, you need to understand what's going on in an instrument. When you make an analysis, you need to understand how that process works chemically in order to interpret those results. Because if I stand up in court and say, well, this instrument just gave me A, B, and C, if I can't explain how it got to A, B, and C, I'm not a scientist.
And that's my first question of you is, well, tell me how that machine works.
Works, absolutely.
And if you're in a courtroom, you darn well better be able to answer that question.
How that instrument works, yes.
Including the idiot questions that the cross-examiner might ask you about, because the cross-examiner may not understand how it works, and the part of the process is for you to teach the examiner and the jury,
right,
and in some cases the judge,
absolutely,
what's really going on here.
Yes. When we teach students, it's about how do you present evidence in a way that it is meaningful to the court and the jury without denigrating the scientific value of that evidence. And it's quite a fine line. And I think this has led in the past to oversimplification and the incorrect evaluations being made. If you know, words play a huge role. So the word that you choose, if I say this is a match, you know, a juror might interpret that, well, it's from that guy, but that's not necessarily true. So I've got to use the correct words to be able to present that evidence that shows what the actual value of the evidence is, and not just simply, you know, use a word and hopefully the jury will understand.
And one of the things that is important for the scientist who's giving this testimony to recognize is what is the meaning of that evidence. For example, you have a DNA sample, you test it, and you found in your testing that it came from me. Mm-hmm. Now, how that test is run exactly is not important to this discussion, but you get a result that is, it says that's his DNA. What does that mean? Does that mean that I committed the crime? Does that mean that I was there? Actually, what it means is the sample that was examined is consistent with having come from me. It means no more than that. It means no less than that. It's up to all of the circumstances of the case to identify significance. And that's kind of where you serve that gatekeeping function, Judge.
Yeah, it's making sure that not only is the scientific evidence reliable, then it has to be relevant to the proceedings before you. And that relevance is often demonstrated by other evidence from other sources. And in a sense, very often the forensic evidence is just one piece of a puzzle that has to be put together to at least try to offer, from both the prosecution standpoint and the defense standpoint, you know, a picture of what happened or what's involved in the case. And Keith's observation about sometimes oversimplification. Occasionally lawyers are guilty of oversimplification of the science, or they may want to take the science somewhere where it doesn't go. And that's part of the challenge to being a scientist who's testifying in court, and it is making sure that not only in, well, of course the only thing you have control over is the testimony, but making sure at least in the testimony the science is accurately represented and that the lawyer is not overstating, or in some cases very rarely understating the effect of the science. And that's part of my job, is to make sure that's not the case.
We're talking about forensic sciences. My guests are the Honorable Russell Clodges, Judge of the Circuit Court of Monongalia County, West Virginia, and Dr. Keith Morris, Director of the West Virginia University Forensic and Investigative Science Program. I'm Dan Ringer, and this is The Law Works. We ought to mention that the three of us enjoy this. Keith, you're a chemist, PhD chemist. Yes. Judge Clodges, you were a mathematician in your previous incarnation.
A long time ago.
And at about that same time, I was trying to become a physicist. So we enjoy these kinds of things, and we enjoy the analysis of it. But these things are so vitally, vitally important. As an example, The Innocence Project, which most of us have heard of, is a project designed to reevaluate criminal convictions in major cases to determine whether the evidence was sufficient to support that conviction based upon what we know now. You go back and reanalyze DNA evidence, for example. So if they do DNA analysis and they find that the DNA's from somebody else, everybody goes home?
Not necessarily. And again, it gets back to this issue of that evidence is a part of the equation that determines guilt or innocence, or determines guilty or not guilty, or whether or not somebody goes home. In some cases, the DNA evidence can be conclusive, and in some cases it does result in people being released. From the standpoint of, in the earlier cases, the cases were based so much on, could have been other blood evidence or other evidence that the DNA evidence now shows was not totally accurate. And without that evidence, the case can't proceed, then somebody may be released. In other cases, the DNA evidence is just part of the picture again, and you have to go back and reevaluate. It may result in a new trial using the new evidence. Sometimes, and actually the last case that I had involving DNA evidence looking into a prior conviction, the DNA results were ultimately inconclusive in the sense that the evidence didn't exonerate the defendant. It actually pointed toward him, but it wasn't conclusive enough for the DNA analyst to say that it was his DNA.
Yeah, that raises a lot of interesting issues. DNA testing can do one of, what, 3 things? 2 things?
Pretty much 3.
What are they?
It can make a conclusive determination, and that is that the sample is sufficient, that there's an adequate analysis of the DNA. It can determine that there is or isn't a match. It can determine that there's not a match, that it's not the same person's DNA. And in cases like I mentioned, sometimes because of degrading of samples and things of that nature over time, a lot of the Innocence Project's cases, we're looking at old evidence. Evidence that may not have been stored properly over the years, evidence that's degraded over the years. So the DNA that was in that evidence is not as readily available to the scientists as it might have been otherwise, and you may get inconclusive results. The example that I gave you with the case that I recently had, what happened was they used like a 16-panel match. Well, it matched over several of the panels, but it would not match over all 16 because they did not get good results over the 16 panels. So the results were inconclusive.
So DNA evidence can be used to exclude somebody.
Can.
You can say, this just isn't that person's DNA. Or it can be inconclusive because the sample has degraded. Are there other things that might make it inconclusive?
Could have been inadequate in the first place, I suppose.
Not enough sample in the first place. But in general, for any forensic evidence has those 3, if we're looking at identification type evidence, either I can link this evidence to that donor, or I can exclude them, it is another donor, or I can't say either. And it basically, the way you want to interpret that evidence is, and the way we teach our students is, we look at both a prosecutorial and a defense hypothesis. And basically what the prosecution says, the accused is the person who committed the crime. And in general, the defense will say, it wasn't this individual, it was someone else. So what we can look at, if we take, given that evidence, given I have this DNA profile and it matches the DNA profile from the accused, what is the probability of that evidence? And I can assign that a value. Or I can say, given that this matches, but it comes from a different person, which conceivably could occur because our DNA analysis evidence is statistically based, that's going to be a very small number. So, you know, from basic arithmetic, if I've got a very large number over a very small number, I end up with an even larger number. And so this evidence supports that prosecutorial defense hypothesis. So it's large support to to the prosecutorial hypothesis.
And the key word there is support.
Support.
It's not conclusive of guilt. It just says
conclusive of guilt.
That based on what we looked at, this could be supportive of a conviction, it could be supportive of innocence, and Judge, you have to look at everything, and you direct the jury to look at everything. Are there witnesses to it? Is there a confession?
Sure. And juries have to take that whole picture and make decisions, and I guess the best example I can think of is the O.J. Simpson case. You know, a lot of talk about it. There was DNA evidence in that case, yet a jury chose to find not guilty.
So it's not just science that determines these outcomes. Dr. Keith Morris, Judge Russell Clauses, thank you, gentlemen, for being with us.
Certainly welcome.
Thank you.
Thank you also for being with us on behalf of the LawWorks. I'm Dan Ringer. Good evening. On the LawWorks website at thelawworks.org, you'll find a listing of recent The LawWorks programs, additional information about this show's topic, and video of this and recent shows. You can also find the LawWorks programs on YouTube and iTunes. If you would like to suggest a topic for a future The LawWorks show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us email at thelawworks@comcast.net or visit us on Facebook.
The LawWorks is produced in cooperation with the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The LawWorks is made possible by a major grant from the West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and legal system, promoting public knowledge of the law in West Virginia. By the generous support of Software Systems Incorporated, a West Virginia company established in 1975, providing high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems. And by viewers like you.
From West Virginia Public Broadcasting.